brings it all together when it comes to submitting the application and making sure everything's done. Going forward, this year we've started also doing an assessment on each individual application, not only to see if the minimum requirements have been met, but to see if they're actually being implemented at a higher standard as well. And we're now scoring the individual elements on a good, better, best level. And we're using that information also to factor into our underwriting program so that members who do the best job of implementing the TAP elements, not just receiving the award with a minimum effort, are getting even more benefit through the underwriting process on their pricing. And so more and more this is becoming an integral part of how we do our pricing and assess risk for trust members. So it's very important, and we appreciate Carbon County's partnership. This is one of the key ways that we measure partnership levels with our members if they're doing these things. And so we're very appreciative of that. And we also appreciate the commissioner's support of staff as well, because without your support, they cannot make risk management and safety the priority that it needs to be. So we congratulate everybody, and especially thank you. So
I'd like to echo your gratitude for all of our employees. It really takes a team of the entire county to pull off a good safety program, and I think we've got buy-in on all of our departments. Everybody's seeing the value of it, and now they can also start to see some of the returns in that value. So I appreciate it. Thank you for offering this opportunity.
Thank you very much.
Thank you,
Thank you.
Appreciate it. Thanks. Thank you. Item number 1 on the agenda, open sealed bids for janitorial services at the new Carbon County 7th District Court building located at 120 East Main Street in Price, Utah. Seth.
Commissioners, we received one bid for this. And it is from Pines Handyman and Cleaning Service. And it is for a, let me just double check that one. It's for a monthly fee of $5,835. One item with this, they were required to supply a list of workers that would go through that. Before any kind of award can be bid on this one, we have to be able to run background checks on all the potential employees that would be in the court facility. And the RFQ that went out specifically said that we got to determine if anyone has a felony charge, or there's a list of items that if they have anything that follows up in their background check, that they will not be allowed to work in the court facility. So it can't be awarded based off of this one. We'd also like to get this sent over to the AOC and have them be able to review it as well to make sure that it meets what we need to do before because there's more than one player in this than just us that needs to review this. So.
And Seth, I'm guessing we get to prepare the contract for assuming everything goes through, and
yeah,
we'll prepare that contract, correct?
We will prepare that contract. We do have a lease agreement with the Administrative Office of the Courts that puts certain requirements on us that we have to do to meet our contractual obligations. So we will write the contract of their cleaning schedule, but we will also coordinate that. And one of the main points of contact will be the trial court executive over at the 7th District Court, so that the day-to-day, which things, if something's not being cleaned, exactly how they want it or frequency-wise, they will have some leeway to be able to provide instruction on, which garbages are dumped on which days and stuff to accommodate them. So.
Well, I'll make the motion to acknowledge the bid and proceed forward with turning it over to the departments and agencies that need to review it for review and recommendation at a later time.
I'll second that.
We have a motion and a second. Any further discussion? All in favor?
Aye.
Aye. Motion passes. Item number two, approval of minutes. I don't believe we have any minutes. Okay. Item number 3, review and possible approval of a resolution 2018-7 adopting proposed tax rates. Seth.
Commissioners, in your packet, you should have both the resolution and then the calculation for the certified tax rate. In Utah Code, the tax cycle runs that the assessor's office has and from January until the end of May to be able to review and set the values. Then the county auditor calculates with the assistance of the state tax commission the certified tax rate, which is designed to provide the taxing entities with the same nominal dollars or the same amount of revenue that they've had in the past, taking into account the changes in valuation. So if the values went down, the rate would go up to be able to provide the taxing entities with the same amount of tax revenue. So if you look at the rates that we have today, the rates are slightly different from prior year's rates, but they're designed to generate the same amount of tax revenue for the school district in each city and the counties. Tonight we have the county's general levy, which is broken up between general operations and health. That should generate $5,500,760. The municipal services fund levy, which is designed to generate $300,672, and the county assessing and collecting levy, which is designed to generate $896,408. It's our recommendation that the commission adopt the certified tax rate. You have the option to adopt anything up to that rate, but not above it, because we didn't continue with the truth in taxation process last year. So this year you're kind of locked in.
You know, Seth, as I reviewed last year's rates and this year's rates, it looks like they've stayed fairly flat, if haven't decreased slightly in a few of the areas, and I mean ever so slightly.
Yeah, we had some small fluctuations in value, a couple $1 million, and I know a couple $1 million seems like a lot, but when you're calculating rates off of $1.9 billion worth of value, $1 million swing does not affect the rate very much. But we did have a little bit of value change. The assessor's office went through and revalued different areas. As usual, the biggest changes in Carbon County are from centrally assessed properties, your big oil producers, your telecoms, rail car. Those have different value changes, and we participate in those appeals, and we have some appeals that we've taken care of through resolutions, but other than appealing those values, we don't have a lot of authority in whether they change or not. So.
Correct, but with the little bit of growth that we did experience this year, it has also made a difference in that slide between centrally assessed taxes and what our general fund really is. So that's good news.
It is. This is, in calculating the rates this year, it was much more heartening than in prior years. In prior years, we've taken quite a beating on the centrally assessed. This year, we came out okay.
And this was the first year that I can remember being on the commission that new growth actually outpaced the centrally assessed slide.
Correct. We did,
not by a lot, but
we did get about $1 million of new growth. It's a smaller amount, but it's going in the correct direction. So,
right. Okay.
I'd make a motion we go ahead and accept the proposed tax rates for the coming year then.
And I'll second that motion.
Motion and a second. Any further discussion? All in favor?
Aye.
Aye. Motion passes. Item number 4, consideration of possible adoption of ordinance 496 for snow loads in Carbon County. Christian, is this something that you want to cover?
Sure, I'll talk about it for a second. Commissioners, as you know, Carbon County, along with all other counties in the state of Utah, are required to abide by the International building code as adopted and amended by our state legislature. Generally, they just adopt almost all the provisions of it as it's modified from time to time. Recently, the draftsman for the state for the building code, who work in the state of Utah, updated the map showing different snow loads, and they've updated that map with new information. They've done a snow load study to determine what kind of criteria and design requirements should be required on roofs of buildings that are in high snow or medium snow areas, basically anywhere in the state of Utah. And so they've updated that map, and based on the changes in that map, there may be changes within certain parts of the county that might cause a change in the snow load design and building criteria and design elements in all the structures that are built. So if we were to adopt this, we would abide by this map and go by the recommendations that follow based on where your proposed building is on the map. It's my understanding, talking with Ryan Monson in our building department, that the map actually improves things or makes things slightly easier for a lot of our areas in the county, in that it does not, it's a more precise detail as to where you have to have extremely high snow load bearing structures or design elements in your structure. So for most areas, it's going to make it somewhat easier to engineer a snow load on your building. And I believe that comports with your conversation with him as well, Commissioner Potter. Is that correct?
It did. He talked about that specifically in the Schofield area with the map realignment, that the snow load would go from 173 pounds per square foot to a 90 pounds per square foot, which is significant in the cost of building trusses and so forth that would support that snow. And so as he explained it to me, I could see that it would benefit. I did further talk with him about one of my other concerns in that is that sometimes as the state adopts and passes legislation just to make the international code what all the counties have to follow. And that doesn't always work for Carbon County, and especially for rural Utah. We've had these discussions with other counties. And so the one thing that I asked him in reviewing the second part under A, as far as the adoption of the load map, is if he saw any problem or issue if we, down at the last line or the last sentence in this, it reads, in the event that this map is incorporated into Utah amendments to the International Building Code, this ordinance will be deemed null and void. I asked him if we were to strike that, if that would cause him any issues as an inspector, just simply because our code or our ordinance would already be in place regardless of what the state chose to do with that, which would still benefit the citizens. But I hate to pass an ordinance and then make it void just simply because of an international code that the state would adopt.
So he told me about that part, and I pulled that out of the draft that I've given Rita, assuming that you would probably all agree with that amendment. So the draft that I prepared, the final draft that I prepared, is actually remove that language out of there.
Do you see any problem with that?
No, I do think, though, if the state does say this is now part of our building code, that would, if we were to have to enforce that provision, we'd probably enforce it through our state building code rather than through, because until it's formally adopted and becomes part of the state building code, it's at our option to adopt it early. But once it's been adopted by the state, then I think it's mandatory upon us. So I think it's fine to take that language out, but I would think if there were ever an enforcement action, it would be the state building code at that point that would supersede our ordinance once it becomes part of the ordinance. So what I tried to accomplish by that sentence is going to happen by operation of law anyway. Right. So I think it's fine to take it out, sure.
Sounds like it'd be fine to leave it in or take it out.
Either way, but if we take it out, that's fine. And
because all you're doing is identifying the natural process that would occur.
Right. Yeah, that's right. So I don't know that it matters one way or the other. I think what we could do is, you know, we can always rescind the ordinance later as well. Between now and the time they adopt it, though, I think the critical thing is we have that ordinance that will benefit our citizens as they build. So,
And I'm fine with it either way.
I'd make a motion, Commissioner Hope, so we adopt ordinance number 496 with the deletion of the last sentence in section A and move forward with. And as it states here, it could become effective immediately.
We have a motion.
I'll second that motion.
Any further discussion? All in favor?
Aye.
Aye.
Motion passes. Item number 5, consideration of possible approval of Indigent Defense Commission grant terms, including project summary, State of Utah standard terms and conditions for services, grantee assurances, conditions, certifications, and requirements, and carbon project plan. I believe this is also you, Christian.
sure, Commissioners. As you're aware, we applied for a grant to help supplement the funding that we're paying for our local public defenders. The grant terms and conditions that we need to agree to have been sent to us. As part of this grant, we have the summary of the dollar amounts that are going to be provided to us. Just to run through some of those, that's on page 2. We've been offered $2,000 for personnel expenses in helping to build our reporting system that we're going to have to use. We've also received $90,000 that will help to supplement the payment of public defenders in our area. We've also received a grant of $10,000, which those public defenders can access for special costs such as investigators, expert witnesses, laboratory testing, that kind of thing. They've also granted $1,200 for those public defenders to use for continuing legal education funds, and they've given us $5,000 to use our software developers to develop the reporting systems, which are quite extensive, that we're going to have to follow. In other words, we're going to need to track the kinds of cases our public defenders take, whether they're felonies, misdemeanors, child welfare cases, parental defense cases, that kind of thing. We have to keep track of all of that now. And so those are the elements of our grant payments that we're expected to receive. The real meat of it comes on pages 8, 9, and 10 of this grant. And I just hit maybe some of the highlights of what we're agreeing to if we agree to accept this grant. If you look on page 8, number 2, it indicates that the funds we receive won't supplant already current levels of spending. It also indicates we need to name a program director who is responsible for planning, operation, reporting, and administration. My recommendation and the recommendation of the Indigent Defense Commission would be that that's a county commissioner who would kind of oversee to it that somebody's sending in the reports on time, that the public defenders are doing their job, somebody who's willing to talk with the Indigent Defense Commission and the necessary parties here on the local level. So probably one of you commissioners, I would recommend ought to be one of those, ought to be that program director. It also indicates that the counties to submit quarterly reports, progress reports, and financial status reports. Some of those reports include the number and types of cases filed, the disposition of each court-appointed case, and caseloads by court-appointed attorneys. And those are all to be, so we're developing some software programs that will track all of that. That's part of what the $5,000 is supposed to help us purchase through our Justware software system. What the county would do then is they would submit a request for reimbursement on a quarterly basis in conjunction with submitting our quarterly reports. That's detailed at the bottom of page 8 under paragraph 1, compensation and method of payment. That's basically the gist of it. There are some things we cannot purchase land with this grant money. as if we had any intents to do that. And a lot of other things. They have the right to come and audit our expenses and use of these funds. We're to maintain the records we have for 6 years, which is no problem. We'll just store those. Well, it might be more of a problem for Barry, but our Justware system will generate those, and we won't delete them. But
We're already doing that anyway.
Sure.
With it.
so really, the rest of it's pretty standard stuff. There's an admonishment to abide by their principles and goals and ethical requirements, which frankly are all set out in the contract that we have with our public defenders anyway. So I see no reason not to approve this. I would just think that you ought to make a motion to also nominate a program director along with your motion to approve it if you're so inclined.
Okay.
One question, Christian. Where this contract involved Don Torgerson,
Yes.
is there anything there that we need to modify
I
on
can
page
tell-
13?
He has a name that he'd like for you to consider, and I think we need to have this gentleman come down and meet with you, because under the contract you have with the public defenders, you have the right to appoint a new person, and you have the responsibility you have the veto right over that. They're basically supposed to nominate that person, but you have the right to meet with them. So under 13, I guess I think it's fine to approve it for now, and then substitute this gentleman's name in if you decide to accept him as the replacement for Don's portion of the contract.
I think the other thing to note is that this is a 2-year contract, or a 2-year grant.
Yes, I think that's
that we
important.
can keep reapplying for, but for
That's
right now
correct.
it's just 2 years.
Right.
Any other questions, commissioners?
I don't.
So in the motion, do we need to acknowledge that substitute individual that we'll be meeting with, or is that separate?
I don't think you need to indicate that at this point. The gentleman's name is Aaron Weiss, or Weiss, W-E-I-S-S-E. He works at the firm, I believe, of McKellen Weiss, or Weiss, out of Spanish Fork, Utah. He's been temporarily receiving appointment on some cases. But I think there are some questions we need to figure out, such as, is he going to be available to meet with clients here in Price? So I don't think it's appropriate to substitute his name in there right now at this point until you're comfortable with him and until you're certain he's the one you'd want to fill.
Until
Fill
procedurally
those
we do
shoes.
our due diligence or whatever, right?
Right, yes.
Okay. Do we have a motion?
I'll go ahead and make a motion. I'm just trying to make sure I state it correctly. Move that we approve of the Indigent Defense Commission grant terms, project summary, terms and conditions for services, guarantee assurances, conditions, certificates, and requirements, and carbon project plan as lined out. And I would also add to that motion myself as the director for this, since I was involved with Jerry Gamber, who helped write the grant and provided it to our council, and I serve with the intergenerational poverty, and currently it kind of aligns with my other jobs and duties.
Okay. A motion?
I'll second that.
We have a motion and a second. All in favor?
Aye.
Aye.
Aye. Motion passes. Item number 6, approval of amendment to agreement with Johansson and Tuttle for the 2018 Hilltop Road improvements. Commissioners, as you remember, we have a contract with Johansson and Tuttle for the design and engineering of the Hilltop Road. As part of that, there are some some things that need to happen, some right-of-way acquisition, dedication plat, and boundary surveys that need to be adjusted to be able to fulfill the mitigation on our water excess water that's coming off of the property. As part of that, they have 3 additional tasks. Task 1 would be the dedication plat for the Hilltop Road. Task 2 is install right-of-way markers. Task 3 is boundary survey for Richard Lee property. Richard Lee has if everything goes through, will give up a portion of property that has some retention basins on it that we can use to do our mitigation, our water mitigation. The total cost for all 3 tasks is $7,800. If we approve this, then they will move forward and continue the engineering on that project. You have any questions?
Just one question. If there are any surprises throughout this process, would that then change the outcome of them continuing?
What kind of surprises?
Just with the survey, well, I don't expect any surprises really. It's just any of the landowners not agreeing or anything like that.
There is that risk, at which point they are, Christian, correct me if I'm wrong, they're still liable to pay for the engineering that does happen.
Yes, that would be on their tax bill.
But then the project would just not move forward.
Okay, I just wanted to identify that was all.
Okay.
I'm,
That's a good question.
yeah, I'm ready to make a motion if there's no other.
Okay.
I'll make
Do you
the
have any questions?
I'm good on that.
Make
Okay.
the motion to approve the agreement with Johansson and Tuttle for the 2018 Hilltop Road improvements.
Okay.
I'll second that.
Motion and a second. All in favor?
Aye.
Aye.
Motion passes. Item number 7, review and possible approval of revised contract with Lantis Fireworks for fireworks display at Carlin County Fairgrounds on July 4th and July 6th. Commissioner Miller, do you want to take this?
Yeah, not a problem. So every year we've had pretty much the same contract with Lantis, and this year we're not spending any more money. We're using the same $10,000 that we spend every year for the Energy Days fireworks show, but we're also including a little mini show carved out of that for the Friday event, which will be the bull riding event. During the bull riding event, there will be a slight intermission as they're changing around which bulls they'll be using. That'll happen right around dusk, and so there will be about a 2-minute show. And for Lantis, with their insurance and their pyrotechnic people who will be here, they had to get they had to list it separately, schedule it separately on their insurance for different days, which if we approve of the revised contracts, there's actually 2 contracts totaling for an overall amount of $10,000, which is the same that we've always allocated for this. It'll facilitate their need for their insurance to make it that way, having us do these contracts.
Okay. As I reviewed, I just had 2 questions. On the July 4th, this is kind of a non-issue, but the July 6th, where are you going to shoot off the fireworks for the Bulls event? Because it states that they need a map of current areas. Have you talked about that? Do you already have your spot picked out, and have you sent them a map? That's my second question. Who's going to come up with the map, and have you sent that to them so they know?
So we have a proposed map,
Okay.
but we want to get the Fire Marshal, Paul Bedont, to review it because he has to okay it anyway.
Right.
He has to okay all the locations within our area,
Okay.
and he just needs to formally do that, and then it'll be sent off to them.
Okay, perfect. That was my only question, because it has to be so far from structures and so far from other things, and typically that's done fairly close to the arena, and with the Bulls there you have to move it away from that. So I just wanted to clarify. Any other questions?
I did have just a couple. One, again, within the contract, they'll be the ones that are lighting the
Yes.
fireworks and staying over or taking care of that. And the second question pertained to, as far as where we are with payment on this, because we approved original contract. I don't know if we've made the initial deposits. Just to follow up on the financial side of it.
So I do recall that we did sign a PO for $10,000. Seth, I'm not sure if you guys have sent them a check yet.
I don't know if it was in this last check run or not. We've been-
They said either way, if they receive a $10,000 check or 2 smaller checks, that it would be the same to them. It was just for their insurance. They needed the 2 contracts was what they were after. So
Okay.
did that answer the question?
I do have one more question.
Go ahead. No, I didn't have any.
From my understanding and talking with Paul Bedont, who's the fire chief, he said you were going to potentially provide a, what do they call that? It's not a safe, it's a
Storage.
storage facility for the fireworks. Is that been okayed as well? Because they don't want to bring them down 2 different nights. They'll just bring the whole show for both fireworks and store the
Yeah.
6th.
We actually are able to have a little bit more of a show by not incurring the cost of them transporting them twice.
Right.
And Paul Bedont, again, needs to be the one as the fire marshal for our area to okay of that storage facility. We have a couple locations out there that we've identified that would suffice because they're far enough away from existing structures, and they're not next to any flammables, and et cetera. There's a list. And Paul Bedont, again, just needs to give Lantis the surety that he approves of that location.
Yeah, powder magazine, that's the word I was trying to come up with. So, okay, as long as all those details are being handled.
Yeah.
Okay, thank you. Any other questions?
I don't have any.
No, I'd go ahead and make the motion that we approve the revised contracts with Lantis.
I'll second that.
We have a motion and a second. Any further discussion? All in favor?
Aye.
Aye. Motion passes. Item number 8, consideration of possible approval of acceptance of a NRCS grant and agreement award for emergency watershed protection EWP projects for Spring Glen DSR, Carbonville, Price, Landfill DSR, Gordon Creek DSR, and South Meadows and Westwood DSR. Commissioners, as you were aware, we've kind of had some of these discussions. EWP came out just a little while ago and said that they would fund all outstanding DSRs. We had 4 DSRs that were outstanding. We still don't have the money in the account yet, so we haven't moved forward with any of the engineering, but this is just part of the agreements to be ready to move forward on those projects. The total amount of grant dollars coming in is $2,624,323. There is a match on that can be a in-kind match with rock, materials, labor, and typically the way we've structured those, the EWP projects that we have used match money instead of hard money to do that. And that's the goal on these projects as well, is to use soft match or in-kind match to complete the projects. The other favorable thing on this is they're under one DSR or one agreement. So if one project has more match to it than the other, it counts for the total project as a whole.
Commissioner Hopes, I didn't, and I don't know if you have an answer to this, but I was curious if you have an estimated time to completion for some of these projects, as well as are there within this contract, I wasn't able to find any time restrictions for their completion?
There is a time restriction. I can't remember. It's either 120 days or 190 days from the time the money hits the bank. 120 days or 220 days. So yes, there is a time frame that includes the whole project. You can apply for an extension, which gives you, I think, another 90 days, 60 days, something like that. There's some leeway there. but any further extensions get a little bit iffy after that. You certainly want to be under construction and moving along in the project before you file for an extension.
Mhm.
So,
Okay.
yes, there is a deadline for these.
Yeah, I just thought that would be important to mention, as these projects are all pretty critical, so.
Another point of note, Curtis has been working on some RFPs for engineering. All of these projects, except for the Price project, the Carbonville Price landfill DSR. So the Spring Glen DSR and the Gordon Creek South Meadows and the Westwood will all go out for RFP. The Price DSR is mainly situated in Price, and they already have an engineer on board, and they will be in control of that project.
Commissioners, as we're putting together those RFPs, one of the things that needs to be understood by all the either the contractors or the engineers that work on those, is that the county really doesn't have the funds available to float the cash flow of another $3 million EWP project. NRCS is notoriously slow. We've had some reimbursement requests that took 7 months to get paid through. So as we put those together, we need to make sure that those contractors understand that it's not going to be a net 30. They submit their bill and they get paid. We need to make sure that we work in something else on that so that they understand they will get paid when NRCS releases the funds, and we can't be stuck in the middle trying to take care of them and their cash flow needs and us. And it may create an additional burden on some of those contractors, whether or not they want to bid. But I think we need to make sure that people know, we cannot cash flow a project of this size for an extended period of time if the NRCS is slow on a reimbursement. If they're 6 months behind, we won't make it. So.
Okay.
Commissioner Hopes, two other things that I also had a question on with this is time frame. We talked about the length of the contract, but is this work we anticipate this year with these funds because of the dating on it?
Yes, it's a matter of when the agreement is signed. That starts the clock on the 220 days, and like I said, we're waiting for that signature at the state level. I was told that the money is in the state's hands, and we're waiting for the state NRCS individual to actually sign off and start the clock. One of the problems we had with I think it was the Canal DSR is they signed the agreement, and 60 days in, 30 days in, they told us to get started, and we lost a significant amount of time for the completion of that project. So we're trying to change some of that by being completely ready to get our engineers on board and start the project as quickly as possible.
The other question that I had is where one of these areas does fall within Price City and there is a matching requirement. Has that been worked out with Price City, and where are we as far as concerning that portion of the project?
So typically the way we've done this, and we've had NRCS projects with other cities like Wellington and Helper. Any project, anything done in their project or city limits is their responsibility to come up with the match. Okay. We have been working on that agreement. I think we already signed that agreement in the last commission meeting.
We've got an agreement for one or two of these. I know. I think it's the Carbonville Price landfill DSR. I know we've gotten I'm pretty sure we have an EWP agreement, an MOU agreement, but with the city on that one for sure.
And that's the one that would be for Price.
For Price,
we
yeah.
signed that last week, or last commission meeting. Okay.
Or earlier even.
Yeah.
Maybe it was last commission meeting. But yeah, but I'm pretty sure we've done one for them. But yeah, on all of those we indicate that matching funds have to be paid by the city or the entity, And if the county does put up any matching funds, they have to reimburse us for those matching funds.
Correct.
If I remember right from the last meeting where Russell Seeley spoke to it, he had sent a letter and we just needed to verify, like it had previously been signed, we just needed to verify that we had received it. So I think that was taken care of.
Yeah, and that was a right-of-way issue. They're responsible for getting all rights-of-way for their project to happen, and that falls on the city as well.
Thanks for clarification where I was gone last meeting. That's all I had, Commissioner.
Okay.
I'll go ahead and make the motion to approve the acceptance of the NRCS grant and agreement award for emergency watershed protection projects for Spring Glen DSR, Carbonville Price, Landfill DSR, Gordon Creek DSR, South Meadows, and Westwood.
And I'll second that.
We have a motion and a second. Any further discussion? All in favor?
Aye.
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 Motion passes. Item number 9, consideration of possible consideration of appeal for grandma request by Roy Robertson.
Commissioners, could I ask that we table that one till the end of the meeting? I would like to ask you that you go into a closed session on that one because it involves allegations of criminal behavior and an ongoing investigation that's not public at this point. And so if we could proceed to the other item, the final 2 items of the agenda, and come back to that one afterwards.
I'll make a motion to move that to the end of our agenda.
I'll second that motion.
Okay. We have a motion and a second. All in favor?
Aye.
Aye. Item number 10, public hearing to consider vacating Oliver Lane as public right-of-way. And since we are past 5 o'clock, we can start that public hearing. Anyone that would like to speak to this, please come to the mic, state your name for the record, and we'll allow you a few minutes to speak to it. And
Commissioners, can I perhaps be first on that as by way of introduction? And I'd just like to indicate why, as you know, we've looked at this, just maybe give the public an indication of why you've asked me to put this on the agenda for you and to prepare a draft ordinance. As you know, I prepared a draft ordinance, and it includes the basic reasons why you're considering vacating this road. A couple of reasons are, number one, that the public at large is not served by the road. The road is a dead-end road. It does not lead to any public lands. It doesn't access upon any public roads. You can access this road in the Westwood area, the Gordon Creek area, by turning off of Gordon Creek Road, but once you're onto Oliver Lane, it does not go to any other public roads. It doesn't go to any businesses or services which accommodate the public. The next point is that approximately 5 owners of private property adjoin the road, and according to a title report that you asked me to have done by professional title, all of the owners of the road have a legal right to access their properties along that road. In other words, they all have recorded written easements such that if the road were vacated, they would not lose access to their properties. They have permanent, perpetual easements to their properties. So I don't see that the road would result in a loss of access to the people who live on that road. And finally, the other reason why I would ask that you consider, or why you've considered vacating the road, is that the road is narrow and very difficult for our county vehicles to maintain. It's hard for them to push snow along the road without knocking over fences. There's really no place for excess snow to be pushed. There's no room along the road right-of-way for a plow to turn around. The county doesn't own the right-of-way necessary to expand the footprint of the road, and basically the county has a hard time getting in there to drop gravel on the road. There's not room for a belly dump to turn around on there. And so bringing the road up to our current road standards would be difficult, and the county has not taken efforts to work on the road for some time. I think it should also be noted that assertions that the county owns the road have not come formally from you, and they haven't been judicially established. In other words, the county commission has not asserted that it's a county road. There was a signature on a subdivision amendment plat from a road supervisor years ago that indicated it was a public road. I believe there have been submissions for B road funds based on that road from several years ago, but the county has not been asking for those road funds for several years now. And so it's just a road that the county cannot maintain and that generally does not serve the public, and that abandoning this road would not be harmful to those who live along it because they have an easement to that road, and as easement holders they have the right to maintain that easement and keep it in good repair and keep it and provide the upkeep for that easement. So I don't see that you're taking away anything from anyone by vacating the road, and I think those are the reasons, as we've discussed, that I think it's proper to abandon the road given that the county road department cannot maintain the road. So those are the reasons that I understand why you're considering this action at this time, and just wanted to introduce the item with those thoughts.
Okay, thank you. With that, just a reminder, please state your name for the record and speak to the specific issue at hand. We'll open this public hearing at 5:19. If you'd like to speak, please come to the mic.
Daniel Hughley, it's my sister, Jacqueline Becker. We represent our mother. She's not physically able to be here. Got thrown by her horse yesterday and is a little injured. So just kind of add on to Christian's summary there. Funds had been taken years and years ago. But yeah, for the most part, I think that's a pretty accurate statement. However, being a dead-end road, I don't know that that's pertinent. I mean, I think most of us in Westwood live on dead-end roads. And I guess a little more backstory there. There's been an issue in, I don't know how to most correctly state this, but an owner wants to put up a gate and block access. That's why this has kind of been to the commission before. Only allowing part of the road to be maintained to her convenience, to no one else's. That's kind of what's been going on, I guess, in the background, not necessarily publicly here, I guess. So that's certainly a concern for a landowner, that would really open the gates for that to happen. Certainly a concern for all of us, and I don't know about the legalities of that, but that would certainly has been expressed that is this landowner's intention to do so. So that's certainly a concern that we have. I don't know if there's something else you want to add to that, but.
So I spoke to somebody who's done.
Please state your name.
Oh, sorry.
Just for the record.
Jacqueline Becker.
Thanks.
So I live in the house that belongs to Carrie Hughley on that road. We've had some issues with the neighbors without getting into he said, she said type of a thing. I do have a recording of the neighbors saying that they have the right and do plan on putting up a gate. Also, as looking to this, if we're gifting the right-of-way to someone, I'm willing to pay for that right-of-way to buy it from the commission, from the county. And I'm willing, I can give you $1,000 today, or we can continue this and figure out how much it's worth, so on and so forth. It is a safety concern for my children. There have been other issues, and I've spoken to Casey about this, where if it's not maintained, okay, I will pay to have it maintained. That's totally fine with me. But whereas there's someone on the road who takes the belongings of the county that have been put on this road to improve it and then puts it onto her own property, and nothing's done about that. That's a problem for me, and if I put my money into doing that, if that happens again, I'm not as able to absorb that cost as well as someone else, and especially a government entity. and again, I'm willing to maintain it at my own cost, but I need to have some assurances from the county that you guys will back me up, that, yeah, you know what, you can't just not improve, and you can't take away improvements.
Historically, I don't believe any improvement's been made in 10+ years. I mean, the county hasn't even tried to do anything in about 10 years. Is that correct?
No, that's not correct. Most recently in 2014, there was $2,021 put into that. 2012, there was $1,889.
Separate issue. You mean that's from the state?
No, this is from the county.
Oh.
Mm-hmm. And then in 2010, there was $4,628, and a good portion of that was labor, but then the gravel that was left on the road, but then taken from the road and put on private property, and nothing was done about that. I've spoken to Casey about this extensively. We've tried to be really civil about this, and I'm not sure what else we can do. I just need assurances from the county that, yeah, you know what, go and improve that. We're going to back you up. That's all we're asking. We're not asking, I mean, you guys make money off this road because the state gives you funding, and it might not be a great amount, but I've looked over the last, well, what was available in the last 16 years, and you guys have made money off this road. And where we're lacking money, it seems a poor decision to give up that money would be my concern. Anything else?
Can I ask a question? Do you know, has she indicated that she plans to lock that gate or just put it up?
She said that she was planning on putting up a gate because she has every right to.
Okay.
Those are her words, and I have it recorded.
She didn't say in that, though, she plans to lock the gate.
She didn't specify that,
she
but
plans to
we've
put up a
had
gate.
enough interactions with her to know that that's...
That would certainly be a huge inconvenience for everyone, right? Have to open and close the gate every time you access your road.
Sure, yeah.
And then it becomes a safety thing, because when it's snowy, and again, I wouldn't even ask you guys to maintain the road. When there's snow there, I just bought a plow truck. I'm willing to do that myself at my own cost. Just help us out by saying, you know, you have the right to do that.
And the other the issues, Katipas is on the kind of the bottom there. Really big pasture, could easily turn around, and again, weather permitting, turn around any trucks or anything. That's certainly something we could work with. The driveways are certainly able to turn around, but it certainly is narrow. That's a valid concern there. So.
Yeah.
And I've spoken to Gopher, and he said that he was willing to sell me part of that property, and if that's what the county needs, I'm willing to do that. Again, I want this to be resolved. I want my children to be safe on this road. I don't want there to be an animal that's at large, which has happened several times, where he's knocked down and he's scared, and he doesn't even dare walk down that road now because even the animal control won't do anything about it. It's an issue.
Okay.
Any other questions to?
Thank you.
Thank you. Anyone else that would like to speak to this? Seeing that no one else would like to speak to this, we'll close this public hearing at 5:26.
Jacqueline, I appreciate your testimony on it. The one concern I have in your one request is that the county doesn't have a right of way to sell you. As I've reviewed the title and the history of it there, it appears very much that each landowner has a right of way to that property, to their respective properties, I should say. And based on private property law, government, in my opinion, does not have a right to interfere with private property. That's my big concern. Is that there's a history with this road of both sides, but the county itself is not, other than with their maps and with UDOT, have not ever really taken this road. I mean, the problem started, I know, years ago. But I feel very strongly that, you know, this is an issue that you as property owners have the right to defend your access, your right-of-ways. Whether a gate's legal or illegal, I don't know. I would not even pretend to guess on that, but I would think that you would have good grounds to stand on as private property and private property rights. Having also gone through the roads with the properties ombudsman, again, because of the title and the history on the roads, there's not a lot that we can do, or, you know, from here we could say, oh yeah, we could back you up on making the improvements. But again, as a government entity, we really have no right to do that based on private property and private property rights. And so those things, I understand why you're asking for them, but I don't see that that's something that this body as a commission could grant. And maybe Christian has other opinion on that, but I see that as very much a personal property issue, and it has been from the very beginning with this. You've got, you know, neighbors that are difficult, you're having difficulty agreeing with in many aspects, and so I don't know where it starts or where it ends, and that's, again, not my role to judge that, but I do appreciate the issues that you're bringing forward, but I do see it as a personal property issue.
Christian, just to clarify, I think if I heard correctly, you had mentioned that all the property owners particular to this road had an easement and a right to maintain their easement. I believe you had said that. And so I guess in accordance with what Jay's mentioning, if somebody's impeding your right to maintain your easement, that would be a civil issue amongst the
It would be.
property owners.
That's right. They have the right to enforce that easement and require that it not be obstructed or destroyed or made impassable. So they do have rights they can enforce. The problem, which I understand and which I think they are emphasizing, is that enforcing those rights becomes costly if you can't reach an agreement with your neighbor. You have to go to court to do that and litigate that and get a judge to sign off on that. So I understand that's not convenient for them, but as you said, they absolutely do have those rights to do so. So they also have the right to try to prove that it is a public right-of-way, which requires 10 years of continuous use by the public. That's the standard way in which a road becomes a public road, is it's taken to court and determined to be a road by a court who says there's been 10 years of continuous open and notorious use of this road by the public generally, as opposed to just the property owners. So you can do it that way. Frankly, I don't think that simply because the county received some road money for this road at one time, that is sufficient enough for us to get a judicial declaration of title that it's our road, which is why I'm emphasizing that to take away the ambiguity of it, that we ought to vacate it and abandon it, because I think if push comes to shove, I can't say for certainty that a court would find that it's a public road or that it ever was a public road, notwithstanding the county's application for funds, because that application for funds is not, while it's of public record, it's not made with notice to the property owners, the adjacent property owners, or the person across whose land that road lies. And typically, unless you're giving notice, I don't think a court's going to just say it's a public road. So I think there's a strong likelihood that the county would not be able to prove it was their own road if this were litigated. And because of that, I think the county should not assert it's a public road and should further remove all ambiguity and indicate that it is not a public road. And especially where the other thing I would submit is that because easements were given down this road, that indicates to me that the thinking at the time these easements were given was that this was not a public road. In other words, you wouldn't give an easement to someone across a public road if everybody knew it was a public road. And so that's why I think we ought to proceed this way. And yes, they do have that right. Unfortunately, it's costly, but they do have the right to enforce their rights of ingress and egress across that easement and to keep that easement usable. They have that right and can enforce that. And they have that right independent of whether it's a county, even if this road's vacated?
Because it's an easement currently, would the landowner in question be able to put up a gate anyway?
You know, I couldn't tell you what the state of the law is on that. There's some, it could be that the court, generally courts look at the historic use of the easement and the reasonable use of the easement. So it might be that a court would say, well, this is an unreasonable restriction of that easement and we're not going to allow it because it's not how it's been historically used, and it's unreasonable to make these people who clearly have the right to be down here to have to get out of their cars to open this gate. But I couldn't say how a court, I couldn't tell you offhand how a court would review that. I don't know that there's I don't know if there's a case on point. There may be, but I can't think of it off the top of my head, a case on point as to whether the placement of a gate on an easement is reasonable or unreasonable. So I'm not of much help there.
It may be the same kind of a question, but with that same kind of a time period of 10 years, 5 years, would there be some of that timing that would apply to a gate, including being included in a road? I mean, if it hasn't had one for X number of years.
That's kind of what I was getting at, is that, yes, I think a court will look at those cases on a case-by-case scenario and would say, the pattern of use here has historically been no gates been required, and this is unreasonable given the pattern of usage. And I think that that's possibly something a court would consider. I just can't cite you chapter and verse on it.
No problem.
Now, Commissioner Holmes, maybe you can remember, but I believe we had our GIS department do a study or an analysis on this road based on the B&C funds received versus the most recent expenditures over the last decade or so. And if I remember right, just as a point of fact, there was more expended than received, and it was not just by a small margin.
I don't remember those figures, but I think you're correct.
So there has been a history of receiving the funds, but the funds actually received are somewhat minimal to the expenses incurred, especially at the risk and liability of trying to maneuver county vehicles on that narrow road.
Yeah, I don't remember those figures, but that's what I remember. And I can't remember the last time. Do you remember when the last time we received B&C road funds on that road?
Yeah, I think the figure cited by Mrs. Becker might be right. It could be that 2014 is the last time. Okay. That sounds right to me. Okay. I won't swear by it, but it sounds accurate to me, and I think she's correct on that.
Okay. Which moves us into item number 11, which is consideration and possible approval of an ordinance vacating Oliver Lane as public right-of-way, ordinance number 497. Commissioners, I do have some more questions because of the gate issue. I know it becomes a private issue that would have to be litigated by the landowners.
And that's something that could be researched. I would just emphasize you don't have to make a decision tonight. You can make one tonight if you're ready to do so, but we could do some more research on that.
Is your question that you have in regards to, are we knowingly putting a litigation burden on the landowners by vacating at this point?
Yes, it is, and I know we don't carry that burden, but I would like to me personally, I would like to do a little more research on what their rights are and before we make a decision, and what the potential costs are. I still think this is the right avenue and the right thing to do. But I worry about putting a burden on these individuals. However,
well, Commissioner Holmes, I actually tend to agree with you. And I would make a motion saying such. I don't know if there's more conversation.
I didn't have anything else to add, Commissioners.
I'll go ahead and make the motion to table or postpone this agenda item for a later decision, acknowledging that we've held the public hearing for it, but that we're going to do some more research to find out what burden would actually be placed on the private landowners.
Okay. We have a motion?
Could we do that by our next commission meeting, which I believe is
Yes.
July 3rd,
I can get that information for you by then.
which is a change of date and a change of day of the week.
That's a Tuesday, right?
Correct.
But I can have that for you.
I'll amend my motion to include
Right.
that specific date and time.
I'll second that.
We have a motion and a second. All in favor?
Aye.
Aye. Thank you, Commissioners. Item now number 9. Christian, I had a question on that where we didn't have it on the agenda to go into closed session. I know, I think we can.
Yes, you can.
Okay.
You can, and I've researched that, and you do have the right to still go into closed session on that. If Mr. Robertson were here, he could stay for that matter,
Okay.
but it's my understanding he's incarcerated right now. But if he were here, he'd certainly be welcome to stay for that.
Okay, perfect. This will take a motion to go into closed session, Commissioners.
I'll make a motion that we go into closed session based on legal and confidence of the issue at hand.
I'll second that motion.
All in favor?
Aye.
Aye. Thank you.